with the learned court below for twice, but the said applications were rejected. His bail application.
The rejection order is necessary as per rules. Otherwise, I will reject it. I will dismiss this. You file heard Mr. M.I. Hussain, learned counsel for the petitioner, who prays for allowing the petitioner to submit and file an additional affidavit bringing on record the rejection order of the trial court. The prayer is allowed. Let this matter be listed on
Saturday, Lordship. I will file tomorrow by tomorrow.
on 19th July.
Item 4. May I please, Your Lordship? Lordship, in this matter, the petitioner was arrested on 4/2/2025. In the meantime, charge sheet was filed, Lordship. And is a matter related to POXO, Lordship.
Charge sheet has been filed.
Lordship.
You are behind the bars.
Yes, Lordship.
Have you prayed for bail before the trial court? Trial court has rejected
Is it
during investigation or
during,
after filing of
after filing?
30 or 31st, Lord. 31st.
31st July.
Withdrawal. Item 6.
Met regular bail application. Petitioner was arrested on 19/5, my lord. Today is has completed 59 days, 60 days offense, my lord. Lordship will find that FIR page 13.
What is the offense?
Offense, my lord, allegation is that he was found along with the prime accused from whose possession some objectionable articles were seen.
Wildlife protection.
My lord. Made it, page 13 is FIR. All the objectionable articles were seized from the co-accused, my lord.
What is the status of investigation?
Today will be record, Lord.
Today is, in fact, 68 days, 59 days complete.
Today is
Today is 19/5, that is 68 days. 6-0.
60. Can you find out whether charge sheet has been
My
submitted?
instruction was successful.
No, it has to be verified. It has to be verified.
After some time.
You verify it and let this court know after some time, before rising.
Item 7.
With your lordship, regular bail application relates to fake appointment of water resource. Lordship, we call for the, please to call for the case diary.
Ms. T. Som, learned counsel for the petitioner. Also, Mr. K.K. Das. Call for the case diary. Let this case be listed on 31st July.
Applies, lordship.
Lordship, along with 7, Lordship, 61 is out of the same Lordship, in supplementary.
61 also.
Lordship, here, Lordship, it's a listed for hearing, Lordship, case diary is there. Yesterday's matter, Lordship, regarding circulation of the fake appointment letter, Lordship.
Is 61 and 61 to 64 and 7 is
We'll go to.
then it will be taken up along with the 6. Your case diary is available.
Yes. My item is 62. It was yesterday fixed.
Okay, let us see whether it reaches or not.
Yes. Because by 1 p.m.
Okay. If it reaches by 1 p.m., we will take it up. Item number 7. Item number 7 too. We'll take it up after, along with 60. Item number 60.
61 and 66.
61.
61 to 64.
You have to wait. We'll take it up. If it reaches today, we'll take it up. Otherwise, we'll take it up along with 61 to 64. It may not reach today.
Item 8. Please, Your Lordship.
Anticipatory bail application, but as FIR was not there, so report was called for from the concerned police station, my lord, as to whether an FIR was registered.
Whether report has,
So I have not received, lord.
find out.
I'm already on interim, my lord, so.
Okay, then heard Mr. S. Nawaz, learned counsel for the petitioner. Learned also heard Mr. K. Das, learned additional public prosecutor, who seeks some more time for furnishing the report which was called for from the officer in charge of the jurisdictional police station. The prayer is allowed. When will you inform? Let it be on 1st of August. List this case on 1st of August. The interim order shall continue till next day.
Deeply.
Item 52 from supplementary list.
May it please your lordship. Lordship, in last occasion, email has been supposed to produce lordship.
What?
In last occasion, lordship, email document supposed to produce lordship. Last occasion. Produce.
What is this? Seeking extension of time for appearance. Then what happened?
Lordship, kindly.
What is your submission?
Something may be granted to appear before the investigation officer, lordship. The petitioner is in Bangalore, lordship, for that one. Some more time may be granted to appear before the investigation.
What is the allegation in the FIR? What is the accusation? What is the allegation against you? Where is the FIR? You come prepared.
And some time may be granted. lordship.
We'll list it in the next week. Heard Miss, what is your name? J. Ghosh, learned counsel for the petitioner. Also heard Mr. K. Das, learned additional public prosecutor. Learned counsel for the petitioner has furnished a copy of the email sent by the petitioner to the investigating officer seeking extension of time for appearing before the investigating officer. Let the said copy of mail be part of record, may be kept in the record as part of record. Learned counsel for the petitioner has sought for an adjournment in this case. Prayer is allowed. Let this case be listed again on 23rd of July.
Okay.
I transfer a matter for time being, your lordship. Just for time being, your lordship.
Okay.
Must proceed.
Get to let lordship. I have other matters.
I think, lordship, before one of our.
What is the matter?
DA case lordship, disproportionate asset.
Disproportionate of assets case.
They're seeking for a B lordship, and it's for the bill.
And lordship, if we go by the record, lordship, the petitioner has been cooperating with the investigating agency, even lordship on the day of the search and seizure.
Then why are you apprehending arrests?
Even lordship, on the date of search and seizure, lordship, I was very much present. Lordship, may kindly come to page number 61 for a moment, lordship.
No, why are you apprehending arrests?
As because lordship, all these sections are non-bailable and maximum punishment is 10 years also, lordship.
But
So
when-
far as section 41A is concerned, lordship, that will not be applicable here, lordship. Without notice, lordship, they can arrest me, lord.
No, they can arrest you, but you are cooperating and they have not arrested you till now.
No.
What cause the apprehension that they will arrest now?
Because of that, Lordship, as because Lordship, the maximum punishment is 10 years, Lordship. I am cooperating, Lordship, and I
Yes,
will cooperate.
will you need,
Lordship, case diary will reveal everything, case diary may be called.
Let the
Because
case
it's an
diary be
economic
called for,
offense, your
Lordship.
Lordship, right now they cannot say they are cooperating or not.
That-
Case diary will reveal, Lordship,
One
but let
page,
me
Lordship, page
take the
number
instruction,
61,
Lordship.
Lordship.
This is a
One
motion
page,
stage, Lordship, at this stage, no liberty shall be given because it's a economic offense, your Lordship.
no, do you need his?
Lordship, let me take my instruction, Lordship, because today is the first time, Lordship. Let me take my instruction.
Let him
and
take
ca-
instructions.
Yes, Lordship.
Lordship,
And-
kindly pass over pass over for the time being, Lordship. Only, Lordship. Yes. And Lordship, moreover, Lordship, if Lordship kindly peruses the page number 61, Lordship. Only one page, Lordship.
No, whether you are ready to argue here or you are taking time.
I'm seeking time,
It
Lordship.
is your first.
I'm seeking
Whether
time,
you are
Lordship.
taking time or you are want.
No,
to
please
argue.
address the court.
Yeah.
Don't argue amongst
Yes,
yourselves.
sir. Because he doesn't want to argue, then later maybe fixed.
When?
My lord, kindly pass over for the time being, Lordship. Senior Advocate, Lordship, Mr. Ken Choudhury will appear in this case, Lordship. Only for the time being, Lordship. He is on legs, Lordship, in court number 7, Lordship. 6, Lordship. Half an hour, Lordship.
If we pass it over, it may not reach today.
Then, Lordship, as a last item, Lordship. Okay.
No, then we will fix it on Tuesday. Let him get,
Definitely.
let him get instructions.
Monday? Tuesday.
Heard Mr. M. Ahmed, learned counsel for the petitioner. Also heard Mr. what
PJ
is
Burman, Lordship.
P.J. Burman, learned special public prosecutor,
Yes, assistant special.
assistant special public prosecutor of special public prosecutor. Learned counsel for the petitioner has prayed for an adjournment of this case. As the senior counsel for the petitioner is on legs in a different court. Stop. The prayer is allowed. Let this matter be listed on 22nd of July 2025. In the meanwhile, the learned assistant special public prosecutor shall also take the instructions whether custodial interrogation of the petitioner would be necessary in this case or not. Let this case be listed accordingly.
Till then, may I pray for some interim?
Till then, nothing.
Item 54.
May I please, your lordship. So the FIR number is at page 16. I am not named in the FIR. And on page 16, my lord.
Yes.
But on, may I read, my lord?
Yes. What is the offense?
Offense, my lord, registered, my lord, under section, my lord, 305E and 317. Theft in, my lord, allegation of government property as well as, my lord, stolen property. Now, the petitioner, my lord, is having, my lord, license of wholesale, my lord, for dealing with fertilizer and agricultural product. I have annexed, my lord, my license, page 11. Page 11, my lord, is my license.
You are not the named accused.
No. And
Hmm.
fertilizer, alleged, my lord, the fertilizer, my lord, was seized in the vehicle. Vehicle is also not mine, my lord. 2 persons were arrested. Then in the vehicle, my lord, one consignment of my shop was found. So I was issued notice under, my lord, section 179. Then I appeared, my lord. Notice, my lord, page 20. Page 20, my lord, annex 4. This was issued by, my lord, Assistant Commissioner of Police Azara, my lord. in connection with this case. And I was asked to appear on 10/7.
Yes.
I appeared.
Thereafter,
My statement was recorded, my lord. I was thoroughly interrogated. And thereafter I was allowed to go, my lord. Subsequently, my lord, another notice, my lord. 35
35.
has been issued, my lord.
Okay.
Against. So I am ready to appear, but now, my lord, they have been made me accused. So I am apprehending, my lord. I will cooperate, I will appear. As I have already appeared, my lord.
Yes.
I insist for calling for the CD lordship to ascertain the truth, as it is, this matter is for supply of urea fertilizers, lordship, subsidized urea fertilizers. So I insist on calling for CD to know his role.
Heard Mr. R. Ali, learned counsel for the petitioner. Also heard Mr. K. Das, learned additional public prosecutor. Where is the subsequent notice?
Case, my lord, 21.
This application under section 482 of BNSS has been filed by the petitioner, namely petitioners, namely Abdul Khalek, who is having license.
Abdul Khalek, my lord, and
Abdul Khalek and
lost him. This is my younger brother.
Fidos Ali Ahmed, who are apprehending arrest in connection with Gorsuk PS case number 194/2025 under section 305 within bracket E/317 within bracket 2 of BNS, read with section 7 of the Essential Commodities Act 1955. The gist of accusation in this case is that on 26/6/2025, one Pranab Jyoti Bhattacharjee, SI of police, has lodged an FIR before the officer in charge of Gorsuk Police Station, inter alia, alleging that on receipt of an information through reliable sources regarding illegal storage of and transportation of urea fertilizer, a search team was constituted and a Naka checking was arranged. During Naka checking, and a vehicle bearing registration number AS15AC 5591 was intercepted, and 80 bags of suspected urea fertilizer and 35 bags of salt and some other materials were recovered from the said vehicle. Learned counsel for the petitioner has submitted that the petitioner number 1, where is the license?
Case, my lord, 11, my lord.
Petitioner number 1 is the
10 is translated copy.
license holder of wholesale fertilizer license, and he further submits that the vehicle from which the seized fertilizer was recovered does not belong to him. He further submits that as one of the consignment found in the vehicle was from the wholesale was, where is that statement?
I'm giving the consignment. 2 days before, my lord. Vehicle number same, my lord. One shop owner from Nolwari purchased, my lord, goods from my shop.
Your shop name is
Agro service, my lord.
from the firm of the petitioner. He further submits that the petitioner number 1, stop. He further submits that the petitioners were issued notice under section 179 of BNSS by the investigating officer, and accordingly both the petitioners have appeared.
One appeared. Notice was against one. my lord.
Accordingly, petitioner number 1 has appeared before the investigating officer and has cooperated in the investigation. And 35(3) notice has been issued against whom?
Against, my lord, one.
Then why 2 is apprehending?
But his brother, he's also, my lord, sitting in the shop, my lord, so and petition number 1 was, my lord, asked to bring his brother also, that's why, my lord.
However, later on, the investigating officer again issued a notice under section 35(3) within bracket 3 of BNSS to the petitioner number 1. Learned counsel for the petitioners has submitted that the petitioner number 2, who is the brother of the petitioner number 1, was also asked to accompany his brother. Now the petitioners are apprehending that as non-bailable offences are involved in this case, they may be arrested in connection with this case. It is submitted by learned counsel for the petitioners that as the petitioner number 1 has already cooperated in investigation, their custodial interrogation may not be necessary as they are ready to cooperate in the investigation. On the other hand, learned additional public prosecutor has prayed for calling of the case diary. Stop. Call for the case diary. Let this matter be listed again on 12th of August. Stop. In the meanwhile, considering the submissions of learned counsel for the petitioners as discussed in the foregoing paragraphs, both the above named petitioners are directed to appear before the investigating officer of Borsuk PS case number 194/2025 and cooperate in the investigation. Stop. If they do so within the stipulated period of time, in the event of their arrest in connection with the above noted case, they shall be allowed to go on interim bail of rupees 30,000 each with one surety of like amount, subject to the satisfaction of the arresting authority with following conditions, number 1 and number 2. Send by list accordingly.
Review. Item 55.
Lordship, here is the bail application. Here, Lordship, petitioner and his wife are medical practitioner, both are doctor. I have enclosed the certificate from page 20 onwards, the MBBS mark sheet and the MBBS degree provided by the college. And thereafter, he has completed some diploma courses at page 27 onwards.
Okay.
Hereafter, Lordship, one journalist has filed an FIR against the petitioner and his wife in the Hojaipur Thana, and thereafter, Lordship, police has registered a case against them. And they are demanding rupees 20 lakhs from the journalist demanding 20 lakhs from the petitioner and his wife for doing practice at Hojai. And thereafter, Lordship, petitioner wife has filed a complaint.
Oh, where is the FIR?
Lordship will find page 40 firstly, complaint filed by the wife. complaint filed by the wife regarding demand of money from the petitioner and his wife. Lordship will find at page 40, the Assamese version.
Okay.
Regarding demand of rupees 20 lakhs.
Why demand is made for withdrawing the case,
No.
for allowing you to practice?
Allowing you to practice at that place in a polyclinic has been opened by taking license from the authority. And wife is a government doctor. And that is why they are demanding rupees 20 lakhs. Lordship will find at page 41. After that, Lordship court has issued notice to the accused, all the accused, namely the person who has filed the affair was the Lordship, the accused number, Jahidul Islam Laskar. Jahidul Islam Laskar. Thereafter, Lordship, they have filed a complaint at page 43. Petitioner has informed the Superintendent of Police also, page 43, regarding the demand of money. They are claiming to be journalist. Lordship, thereafter, they have published some news item at page 47, 48 are the news item. And they have also filed FIR against the petitioner's wife. And ultimately, this petitioner's wife has approached the Ojai court, and Honorable Court has granted interim bail at page 50. Page 50 is the interim bail to the wife. Lordship, what is page 50?
Yes.
That has been made absolute yesterday, Lordship. I have tried to not enclose. Yesterday, that has been made absolute.
Okay. This is a separate case.
Separate case. Now, Lordship, the same person has again made a complaint to the Assam Medical Council. Lordship will find at page 61. On the basis of the affair has been filed. Page 61 is the 11th affair. Lordship will find last paragraph. A complaint petition, page 61, a complaint petition to the Registrar of Assam Council of Medical Regulation. Assam has laws on 29/7/2014 on 30/12/2005 Jahidul Islam Laskar, son of Abdul Hannan, and Abdul Wahid was not registered medical practitioner in the state of Assam, which is mandatory for practitioner of modern medicine. Lordship will find I have not applied for the registration as per provision of law. Lordship, I have annexed the application at page 33. Allegation is that I have not applied for registration. Page 33 is the application that is pending. Lordship, got it? Page 33. Annex of 14.
Yes.
That is the application for registration as a doctor in state of Assam. Because the registration is necessary. That is pending. And on that basis, Lordship, this complaint, police has registered a case against me. I am not practicing, but my wife is practicing as a doctor because he is a doctor of a state dispensary. And on the basis of this, Lordship, police is.
Where is the FIR? At page 61.
Page 61. And that is on the basis of the same
No.
Jahidul Islam.
Okay.
Already I have applied for the registration. And they have also enclosed, Lordship will kindly say one thing. They have enclosed one prescription to be issued by me. Page 56. Page 56, they have alleged that without that registration, I have issued a medical doing prescription. Page 56. Lordship, got it. Page 56.
Yes.
Lordship will find this is a prepared medical document by same journalist. Lordship will find my signature has been written on 27/10/2023. Lordship, got it?
Yes.
My signature. Now I will show my signature, Lordship.
You are saying that this is a fake prescription.
Fake prescription. My signature will be reflected at Lordship page 17, my pen card. Page 17. As well as in present affidavit.
Page 17.
My signature is also A-Y. And this.
But doctors do not use so long
Lordship, but
Signature
this is
in
not my signature.
prescription.
But this is not my signature. I have made a categorical statement. I am ready to send this prescription to the Lordship,
Forensic.
for forensic.
Okay, okay.
So
Yes.
I will appear before the IO for everything, Lordship.
Heard Mr. S.K. Goswami, learned counsel for the petitioner. This application under section 482 of BNSS has been filed by the petitioner, namely Dr. Abdul Wahid, who is apprehending his arrest in connection with Doboka PS case number 122/2025 under section 318 within bracket 4/336 within bracket 3/350 within bracket 1 of BNS 2023, read with section 23 within bracket 1 again within bracket 2 of the PCP-NDT Act 1994. The gist of accusation in this case is that on on 3rd July 2025, one Dr. Abhijit Neog of Anti-Quackery and Vigilance Officer, Assam Council of Medical Registration, had lodged an FIR before the officer in charge of
Doboka Police Station.
Doboka Police Station,
हो जाए.
Doboka Police Station, inter alia, alleging that the present petitioner is practicing as a qualified medical practitioner from his clinic at ATS Health Polyclinic located at Gastola, Purana Jama Masjid, Doboka, without having himself being registered as a medical practitioner under Assam Council of Medical Registration. Stop. Learned counsel for the petitioner has submitted that the petitioner is a MBBS degree holder and has applied for registration as a medical practitioner before the, where is that
Page
application?
33.
Before the Assam before which authority?
Before Assam medical practitioner in state of Assam.
Assam medical practitioners
Lordship, as per Lordship, Assam Council of Medical Registration.
before the Assam Medical Council,
Assam Council of Medical Registration.
Assam Council of Medical Registration, and the said application is still pending consideration before the said council. In support of his submission, he has annexed as Annexure 14 along with the bail application, the application for permanent registration filed by the present petitioner before the said council. Learned counsel for the petitioner has submitted that the FIR has been lodged on the basis of a complaint petition received by the Registrar, Assam Council of Medical Registration, by one Jahidul Islam Laskar, who claims himself to be a journalist. Learned counsel for the petitioner has submitted that the said journalist had said Jahidul Islam Laskar had earlier also lodged a complaint against the petitioner,
Wife,
against the wife of,
petitioner,
only wife or
only wife.
against the wife of the petitioner. And in the said case, the wife of the petitioner, who is also a MBBS doctor, was granted anticipatory bail by the Court of Learned Sessions Judge Hojai in bail application number 254 within bracket H of 2025. Stop. Learned counsel for the petitioner has also submitted that the said Jahidul Islam Laskar had demanded
20 lakhs
demanded rupees 20 lakhs from
from the petitioner and his wife.
the petitioner and his wife for practicing medicine in Doboka. Stop. It is further submitted by learned counsel for the petitioner that the wife of the petitioner had also lodged an complaint case against the said Jahidul Islam Laskar before the Court of Learned Judicial Magistrate First Class Shankardev Nagar Hojai.
That has been registered at CR number.
The said case has been registered as CR case number 754/2024 and in which notices have been issued to the accused persons, including said Jahidul Islam Laskar. Learned counsel for the petitioner has further submitted that the wife of the petitioner has also lodged a complaint before the Superintendent of Police Shankardev Nagar against extortion, against demand of money made by said Jahidul Islam Laskar. Stop. It is also submitted by learned counsel for the petitioner that the medical prescription which is purported to be shown to have been issued by the present petitioner is a fake document and it does not contain the signatures of the petitioner. Stop. He further submits that the petitioner is ready to cooperate in the investigation and he has been victimized by the conspiracy made by the said Jahidul Islam Laskar. Stop. On the other hand, learned additional public prosecutor has prayed for calling of the case diary.
One line may be added. In the FIR, the allegations are specifically described. Only
He's-
one line.
He also submits that in the FIR is filed by the registrar of Assam Medical Council, Assam Council for
Medical registration.
Medical Registration, and specific accusations have been made against the present petitioner. Hence, he prays for calling of the case diary. Other line to continue. Call for the case diary. Let this matter be listed again on 12th of August. Stop. In the meanwhile, considering the submissions made by learned counsel for the petitioner as discussed in the foregoing paragraphs, the petitioner, the above named petitioner is directed to appear before the investigating officer of Doboka Police Station, case number 122/2025 within a period of 7 days from the date of this order and cooperate in the investigation. Stop. If he does so within the stipulated period of time, comma, in the event of his arrest in connection with the aforesaid case, comma, he shall be allowed to go on interim bail of rupees 30,000 with one surety of like amount, subject to the satisfaction of the arresting authority with following conditions. Number 1 and number 2, list accordingly.
Obliged. Highly obliged.
Apply. Move on, item number 9.
Lordship, may I please, regarding item 2, Lordship, I want to withdraw, Lordship. Already talked with the petitioner Michelle.
One more. At the,
He will appear to.
heard Mr.
Remember.
M.M. Rahman, learned counsel for the petitioner. Also heard Mr. K.K. Parashar, learned additional public prosecutor. Learned counsel for the petitioner prays for allowing the petitioner to withdraw the instant bail application. Prayer is allowed. This bail application is dismissed on withdrawal. No, 60, Nija, Homo,
6. Item 60 will appear.
okay, wait for your turn.
Item 9.
9 may be taken after some time, DSBI Architect should be in another court, my lord.
Let him come.
Let him come.
Bail hearing, item 10.
May I please your lordship?
My lord, charge sheet matter, my lord.
Victim yet not examined, my lord. On the last occasion, my lord, it was directed to the trial court, my lord, to take endeavor.
As per the, my lord, latest status report.
Oxometer
Yes,
Also, my lord, latest status report.
no,
on 14th, on
And,
14th of August.
and the latest status could be, if evidence, my lord, here, my lord, that
this
may be
can
called.
be maybe called for, my lord.
After-
Let also the status of trial as on 8th of August be called for from the trial court so as to reach this court on or before the next date, that is 14th of August. Registry to send the requisition for the same.
Item 11.
Wait, please, your lordship. It's a regular bail application, my lord, NDPS 21C and 29 of the NDPS Act. I am in custody for 217 days. So in this case, my lord, initially 3 packets of, my lord, methamphetamine, total weight is 658 grams. These were seized from Ataur Rahman and Khodeja Khatun, my lord. My lord, here, my lord, I am interrupting, my lord, as per the official, my lord, the latest status report has not yet received, my lord. My friend has stated that 2 witness examined, but I have not found that, my lord. What had happened was, my lord,
On what ground you are
in
seeking?
seeking ground on the, primary ground is that, my lord, that nothing was seized from my possession and I was implicated in the case only on the statement of the co-accused, man. So that being inadmissible, my lord, so 37 regards will not be applicable in my case because the foundational case is based on the statement of the co-accused on the basis of which I was.
Apart from co-accused statement, there is
Nothing
no.
is there against.
Case diary is available,
Charge sheeted case, my lord,
but case diary would be required.
required, my lord, that would be required.
We'll call for, no, his ground is only Tufan Singh. So case diary has to be produced.
Was called for, my lord, I do not see today. Up to date, we will not receive, my lord, as per official. CD.
Now verify whether case diary is there or not.
I will take it up after some time in the statement.
Yes, Mr. Parashar, you see whether the scan copy of the case diary is there or not. If it is not there, we'll call it. We'll take it after some time.
Item 12.
Is in.
Sabodio, case diary assigned.
Up to the CDU's official report is not received, my lord.
130 days in custody, my lord. Petitioner is,
What is the offense?
offense is, my lord, 20B to commercial quantity, my lord, 21 kg ganja. Says,
Pending investigation.
yes, my lord.
Heard Mr. M. Kolita, learned counsel for the petitioner. Also heard Mr. K. K. Parashar, learned additional public prosecutor, who prays for some more time for producing the updated case diary along with the FSL report. The prayer is allowed. Let this case be listed again on
29th, my lord.
29th of July.
Your Lordship, the petitioner is seeking bail on mainly on the ground that he was not informed about the grounds of arrest at the time of arrest. That your Lordship will find at page 18, annexure 3. That is the arrest memo. Then page 19 is the notice under section 47 BNSS. Here also only it is stated that in connection with above reference case, he was arrested. And inspection memo, your Lordship will find page 20, annexure 5. He was arrested on 25/12/2024 also. As of today, 148 days.
How much is the contraband?
The Yaba tablet also, 16,290 grams. Page 12 is the FIR.
Yes.
Lordship, see the 47 notice, Lordship, at page 19. In my respectful submission, Lordship, this is sufficient compliance, Lordship, because
Now, where are the grounds?
Lordship, that paragraph itself, Lordship,
There is a paragraph, but what should be there in that paragraph is not there. Why he was arrested? He was arrested in connection with the aforesaid case. How will he know what is there in this? Basic facts necessitating the arrest, that is not there. Which case you are relying?
Pravir Prakash and Bihan Kumar's case.
Heard Mr. A. Ahmed, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor. This application under section 483 of BNSS has been filed by the petitioner, namely Sushanto Rudropal, who has been detained behind the bars since 25/12/2024, within bracket for last 100 and how many days?
180 days it will be.
You have calculated for within bracket khali rakhibo. In connection with Bajari Chera PS case number 211/2024 under section 22C/25/29 of the NDPS Act 1985. The gist of accusation in this case is that on where is the FIR?
The FIR Lordship, page 12.
On 24/12/2024, one Long Sing Crow, SI of police, had lodged an FIR before the officer in charge of Bajarichera police station, inter alia, alleging that on receipt of an information through reliable sources that one vehicle bearing registration number NLAD 61696 would be carrying prohibited narcotic substance, a search team was constituted and a narco checking was arranged at National Highway number 08. Stop. During narco checking, the aforesaid vehicle was intercepted and the petitioner was found driving the said vehicle. On search of the vehicle, what is the weight?
Weight 16, page 12, last three lines your lordship will get 16,290 grams.
16 kg 290.
16,290 grams. 16,290.
16,290 grams of suspected yaba tablet were recovered from the petitioner. Stop. Learned counsel for the petitioner has submitted that the petitioner has approached this court seeking bail mainly on the ground of violation of the constitutional right of the petitioner guaranteed under Article 22(1) of the Constitution of India, as well as under Section 47 of the BNSS. He submits that though at the time of his arrest on 24/12/2024, notice under Section 47 of the BNSS was served on him. However, the said notice does not contain the ground of arrest. It only mentions the case number in which the petitioner was arrested, as well as the penal provisions therein. Learned counsel for the petitioner has cited the rulings of the apex court in the case of Prabir Purkayastha versus State within bracket NCT of Delhi, reported in 2024 8 SCC 254, as well as the case of Vihan Kumar versus State of Haryana and another, reported in 2025 SCC Online SC 269, wherein it was observed that furnishing the grounds of arrest in writing, to an arrestee at the time of his arrest is the constitutional mandate contained under Article 22 within bracket 1 of the Constitution of India, and any violation of the said mandatory requirement would render the arrest of such an arrestee illegal. And in such circumstances, the petitioner is entitled to get bail. He submits that in the instant case also, as the mandate of the Constitution, as observed in the aforesaid cases, have been violated, the petitioner is entitled to get bail. Stop. On the other hand, learned additional public prosecutor has submitted that the contraband seized in this case is of commercial quantity, and therefore the embargo of Section 37 of the NDPS Act is applicable to this case. However, he fairly submits, no, you have submitted that it is, no, he also submits that the notice served on the petitioner under Section 47 is in sufficient compliance of the statutory as well as constitutional requirement, as there is clear indication in the said notice as to in which case the petitioner has been arrested and for what offense he has been arrested. Stop. He therefore vehemently opposed the grant of the bail to the petitioner. I have considered the submissions made by learned counsel for the both the sides and have gone through the records available before this court. In the case of Vihan Kumar versus State of Haryana, the apex court has observed as follows. State of Haryana within bracket Supra, the apex court has observed as follows. Quote para 20 from the said judgment.
For my lordship, paragraph, I'm relying on paragraph 21 and 26.
Also quote para 26 from the judgment. Stop. In the instant case, it appears from the copies of notice under section 47 which is available in the record that only information regarding arrests of the petitioner in connection with Bajari Chera PS case number 211/2024 was informed to the petitioner as no other information apart from the case number and the penal provisions involved in this case, was there in the said notice. It also appears that the arresting authority is required to state the basic facts which necessitated the arrest of the petitioner in the notice under section 47 of the BNSS at the time of the arrest of the petitioner. However, no such basic facts are there in the notice which was served on the petitioner at the time of his arrest. Stop. This court is of considered opinion that the notice under section 47 of the BNSS, which was served on the petitioner at the time of his arrest, merely give an intimation regarding his arrest in connection with Bajari Chara PS case number 211/2024, and it does not furnish the grounds of arrest, and therefore same is in violation of the constitutional mandate of Article 22 within bracket 1 of the Constitution of India, as well as statutory requirement provided under section 47 of the BNSS. Stop. In view of the observation made by the apex court in the case of Vihan Kumar versus State of Haryana Supra, under such circumstances, the arrest of the petitioner would become illegal, and on that ground itself, he is entitled to get bail in this case. Stop. For reasons discussed in foregoing paragraph, the petitioner is allowed to go on bail of rupees. How much is the contraband? Of rupees 1 lakh with one surety of like amount, subject to the satisfaction of the special judge Tribhumi with following conditions. Conditions apni abhishekor pora logo. This bail application is accordingly disposed of.
Problem. That is Lordship 204 days. as of-
Within bracket ji khali asile 204 days.
Problem.
No?
Item 11.
Requisition is there, my lord, but case diary only parts have been sent, so.
Case diary would be required. Stop. Since oh, no. Heard me. This is item number 11. Heard Mr. S. Nawaz, learned counsel for the petitioner. Also heard Mr. K. Parashar, learned additional public prosecutor. Learned counsel for the petitioner has submitted that since the petitioner is praying for bail mainly on the ground that he has been implicated in this case only on the basis of the statement of the co-accused, which, in view of the observation made by the apex court in the case of Tufan Singh versus State of Tamil Nadu. Tamil Nadu. Citation is there.
21,
Reported in 2021 4 SCC page 1
Page 1.
is inadmissible. He further submits that apart from the statement of the co-accused, there is nothing on record which incriminate him in the instant case. Hence, perusal of the case diary would be necessary to appreciate the submission of learned counsel for the petitioner. It also appears that the scanned copy of the case diary, which is available in record, is not complete, and a complete scanned copy would be necessary. Hence, issue a fresh requisition for scanned copy of the case diary of
PS
Ojai PS case number
354 of 2020.
354/2023 from the trial court. Registry to send requisition for the same. Let this matter be listed when
Everybody else is out on bail, man. I'm the only one left.
31 July.
Deep level.
Item 14. Negligence.
কিন্তু আমি আমার ইয়াতে রাখি দিব প্রয়োজন হতে পারে Oh, yes. Yes, Mr. Thakur.
Lordship, charge-sheeted case, Lordship. The petitioner was arrested in connection with Lordship, Procedural PS case number 474/2024, Lordship. And now the trial is pending, Lordship. The case was under section 302, Lordship.
302.
302, Lordship. The petitioner is behind the bar since, Lordship, 9/8/2023, Lordship. And he is all total behind the bar, Lordship, 708 days as of now, Lordship. 708 days, Lordship. And I have taken another plea, Lordship, the ground of arrest, Lordship. The grounds of arrest was not provided to the petitioner, Lordship, as well as the family members, Lordship. In the 50.
How many witnesses have been examined?
Now, 4 witness examined out of total 39, but vital witness, one witness, he was in the spot, but not exactly the eyewitness, but nearby the spot, he was examined, and along with him, other 2 persons were there. There 2 vital witness not yet examined, Let few witness be examined, and he, otherwise, that person said the accused along with that deceased went inside the jungle. Accused is holding a sword, and subsequently he only returned to PW2, and he asked whether that person. So he brutally killed that person around 12 injury mark in the postmortem report, my lord.
Who are those witnesses?
But persons, my lord, along with PW number 22, my lord.
What is their name?
My lord, my lord, witness, my lord, vital witness is there, my lord.
Lordship, already Lordship, it is about 2 years, Lordship, and only
PW number 4 is examined on
out of
6/6/25.
out of 39, 4 only recorded, Lordship. So Lordship, 2 years is about 2 years.
PW 4 on 6/6/25.
And otherwise, Lordship, the ground of arrest plea I have taken, Lordship. I was not being informed the ground of arrest, which was the constitutional mandate, Lordship, fundamental rights of the accused, Lordship, that was violated.
Regarding the ground of
I have annexed, Lordship.
No, who are those witnesses who are required to be? What are their names? You tell me the names. And whether the witnesses who have been examined have implicated him.
No direct, Lordship.
Last scene.
They have seen, yes, Lordship, they have seen that the accused along with the disease and we are there going inside the jungle. That must, they
along with the sword and another boy which in the jungle, he comes alone. Then PW2 asks you why, where is the other person?
What is the next date fixed?
Lordship 21/7, Lordship. Lordship, I have taken the plea, Lordship, the ground of arrest, Lordship.
No, we'll consider that before.
Earlier occasion, the case was also listed with the scan copy and today was, that time was taken for hearing, Lordship.
We'll take it up after 21st. And you point out the names of those witnesses. And
The notices, Lordship, available in the scan copy, Lordship.
notices too?
Notices, Lordship.
No, we are not going into that aspect now. We will examine that. But those vital eyewitnesses,
Lordship, since last 2 years I am in custody, they would have done, Lordship. Only 4 witnesses till now, Lordship. Their prolonged incarceration is also there, Lordship.
find out the names and tag the names. I'll pass orders.
Lordship, the charge was framed on 20/12/2023, Lordship. And since December 2023, only 4 witnesses recorded. Out of
Putul, itu record to the both. We will take it after some time.
Item 15.
Yes.
May I please order? This is a traffic NDPS case purchase. I was arrested on 12/11/2023, Lord. And moreover, Lordship, there are 2 grounds. I have been languishing behind the bar for 20 months. It is 1 year, 8 months. And moreover, Lordship, the accused was served with notice under 50 CRPC. But at the time of arrest, however, it did not contain the ground of arrest. And out of 3 accused who had already been granted bail by this honorable court.
Where is the bail order?
It's the Lordship 36 page number.
How many listed witnesses are there?
Well, 15 listed witnesses, 4 have been examined.
How many have been?
4 examined.
So records are not updated, Lordship. As of 27/3/25, it was fixed for evidence. That lordship status is not there.
Project, there is no any examination of witness already. And the next date is fixed on 27/8/2025.
Yes.
Commercial quantity, grounds of arrest are not there, lordship.
Heard. Mr. What is your name?
PD Bhuyan.
P.D. Bhuya, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor. This application under section 483 of BNSS has been filed by the petitioner, namely Shri Deepu Mohanta, who is detained behind the bars since 12/11/2023, within bracket for more than 1 year, 7 months, 8 months, in connection with NDPS case number 13/2024, corresponding to Mukalmoa PS case number 561/2023, under section 22C/29 of the NDPS Act. Stop. The gist of accusation, quote from para 5 at page 37. 6, 7. What is your name? Deepu
Mohanta,
Mahanta. Who is Tapan Mahanta?
his brother. Who it is?
Who are allowed on bail?
Saddam Hussein and Tapan Mohanta.
Where is Saddam Hussein's bail order?
I have not annexed that project book.
Okay.
Because Saddam Hussein,
Learned counsel for the petitioner has submitted that the petitioner was arrested in this case on 12/11/2023, and he has been languishing behind the bars for last more than 1 year, 8 months. However, out of total 15 listed prosecution witnesses, till date, only 4 prosecution witnesses have been examined. He submits that the petitioner is entitled to get bail for violation of his fundamental rights guaranteed under Article 21 of the Constitution on account of prolonged incarceration. He further submits that the petitioner is also seeking bail for violation of his fundamental rights guaranteed under Article 22 within bracket 1 of the Constitution of India, as at the time of his arrest. Where is 50 notice?
I have not annexed it, but I have flag marked it in the scan copy.
Kili last line. The time of his arrest. He submits that though notice under section 50 of CRPC was 50 of the Code of Criminal Procedure, 1973, was served on him at the time of his arrest, same does not contain any ground of arrest. It only contains the case number in which the petitioner was arrested and the penal provision involved in that case. Nothing apart from the aforesaid facts is there in the said notice. Learned counsel for the petitioner has further submitted that In the meanwhile, two of the co-accused, namely Tapan Mahanta and Saddam Hussein, were already allowed to go on bail by this court, both by High Court,
Yes, Lord.
by this court. And therefore, he also prays for allowing the petitioner to go on bail. On the other hand, learned additional public prosecutor has submitted that the quantity of contraband seized in this case is of commercial quantity, and therefore the embargo of Section 837 of the NDPS Act is applicable to this case. He, however, fairly submits that the notice under Section 50, which is available on record, which was served on the petitioner at the time of his arrest, does not contain any grounds of arrest. So, I have considered the submissions made by learned counsel for both the sides and have gone through the scanned copy of the records of NDPS case number 13/2024, which was requisitioned in connection with this case. In the instant case, it appears that the petitioner has been languishing behind the bars for 1 year, 8 months, more than 1 year, 8 months, and only 4 out of total 15 prosecution witnesses have been examined. Thus, it appears that the thus it appears from the above facts that there is an unlikelihood of early culmination of the trial. The apex court, in many of its rulings, have observed that prolonged incarceration overrides the embargo of Section 37 of the NDPS Act. And in a case where the court is of considered opinion that the incarceration is long enough, in such a case, it may grant bail to the petitioner, to an accused, in spite of the embargo of Section 37 of the NDPS Act, as in such a case, the fundamental rights under Article 21, guaranteed under Article 21 of the Constitution of India, would outweigh the embargo of Section 37 of the NDPS Act. Moreover, in this case, it also appears that the petitioner was not furnished with the grounds of arrest at the time of his arrest, as the notice served on him at the time under Section 50 of the CRPC does not contain any such ground. Quote para 18 from page 39 of the bail application. For the reasons discussed in foregoing paragraphs, this court is of considered opinion that for violation of the Constitution, fundamental rights of the petitioner under Article 21 of the Constitution of India, as well as under Article 22 within bracket 1 of the Constitution of India, he is entitled to get bail. Stop. In this case, get bail in this case. Stop. Accordingly, the petitioner is allowed to go on bail of rupees 1 lakh with two sureties of like amount subject to the satisfaction of the trial court with following conditions. Conditions, quote A from page 40. This bail application is accordingly disposed of.
Item 18. Please, Your Lordship, please not, Lordship. Probably the scan copy has not been received.
Scan copy.
Please not.
Yes, what is the offense?
Hence, Your Lordship. Also, Your Lordship. In this case,
Notice to respondent number 2.
already I have taken step.
Notice also you have to take.
That instruction also, Lordship.
Heard Mr. S. Islam, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor. On perusal of the office note dated 15/7/2025, it appears that scanned copy of the trial court records have not yet been received. Stop. Issue reminder for the same. Registry to send a reminder. Registry to take steps for issuance of reminder. Stop. Learned additional public prosecutor is also requested to inquire about the fate of notice issued to the respondent number 2 through the officer in charge of jurisdictional police station, and let this court know about the same on the next date fixed. Let this case be listed again on.
Approved matter, Your Lordship. So short date may be given. In this case, victim as well as informant and other witness has examined. Out of 9, 4 witnesses has already been examined. And
31 July.
31 July. What? Item 19. Oblige.
Lordship, allow us 2-3 days time to file our update.
My Lord, here in this case, my lord, I am in custody for 2 years, 3 months, 27 days as on today. And what happened, my lord, under same arrest memo, my lord. I was arrested along with 3 other persons, my lord, and they were granted bail by your lordship. And your lordship, times and again,
No, today is the second day.
my lord,
LCR has come.
my lord.
How much time will you take?
My lord, objection, my lord, regarding objection, my humble submission before your lordship. Your lordship already passed order in so many cases. Your lordship will turn to case 29.
No, but they have a right to file objection.
But objection, my lord, for objection, my lord, this case was listed on 1912, my lord.
Because Lordship, officer had.
1912?
Oh, sorry, my lord.
No, today is the second date.
My lord, second day, all right, my lord, but it was on 26, 2025. More than 1 month have gone, my lord, they did not file objection.
Officer has been transferred, new officer has been appointed, Lordship.
Lord, my humble submission before.
Okay, they are seeking time only for 2 days.
On Monday, Lordship.
If they don't file on Monday, we will not give them extension. Heard Mr. M. A. Sheikh, learned counsel for the petitioner. Also heard Miss M. Kakoti. Sorry. Miss M. Deka, learned counsel for NCB, who prays for some time for filing written objection against the prayer for bail. The prayer is allowed. Let this case be listed on Tuesday. Monday will be difficult.
My lord, on Tuesday, my lord.
Tuesday, that is 22nd July.
My lord, may I pray that no objection filed, my lord, my bail will be considered, my lord, on the basis of the materials on.
Reserve it for Tuesday.
My lord.
Reserve that prayer for Tuesday.
My lord, if it is not recorded, you will come for again.
What will happen on Tuesday, reserve for that day.
My lord,
Don't.
last chance is not given. If another plea is taken that this is the problem.
Let us see what plea they take.
Oblige, Lordship.
Item
Yes.
20.
Lordship, please an office note.
I please your lordship.
With the CD Lordship, but regarding instruction of service Lordship, we have not received any instruction.
Oximeter,
Yes. There's an office note in the.
you have taken.
Because my lord, everything has been seized that occurs at page 18, my lord. And 21 days in custody, page 18, my lord. All seized, my lord. Let me face the consequences during trial if I have done something, my lord.
Yes,
Page 18, during the, my lord.
no, what is your main defense? Why you have shown a dead person as
My
alive?
lord, I was at a different place of posting because of paucity of staff, my lord. I was asked to verify over, my lord, technical device online. I verified, my lord. And all documents have been seized, my lord. My release cannot, my lord, with all respect, cause any inconvenience to the police investigation. My lord.
Yes, Mr.
Yes, Lordship. Firstly, I want to state here to the section, Lordship, 120B is there. Firstly, I want to emphasize on that, criminal conspiracy. Then, Lordship, this is Monju Mora died on 24/6/2019.
No, now he has
No,
been.
I will come to it, Lordship. I will come
Okay.
to one by one. 2019. Then the original proposal form is dated 10/12/2020, Lordship. It is after her date. Moreover, the false address is also given in PAN card. Photo is also different of different person. Secondly, I will come to 120B, Lordship. One of the person who is the co-accused, Lordship, he himself stated that he made this fake documents, Lordship, fake voter ID, and he given it to the present petitioner in WhatsApp, Lordship. Screenshots are there. He has every knowledge that this is not the thing. It is not only verification, Lordship. He
No,
also has the knowledge, Lordship, as per the.
no, assuming that
Lordship.
incriminating materials are there.
Lordship.
Now, why do you require his custodial in detention? That has to be justified. That if he is released on bail, it will in this manner hamper the investigation or that manner hamper the investigation.
Because under his jurisdiction, these things are done, Lordship. Because he is the agent, and under his agent, this thing, Lordship, he is doing this. So there is evidence may be fabricated, Lordship, again.
No, but documents have been seized.
And money is intact, my lord, not withdrawn, my lord. And 41 on the top of it.
Money has not been.
No, not withdrawn, my lord. And now I work in a different bank, HDFC, my lord.
Okay. Okay, I'll dictate it in chamber.
My lord, my lord.
30,000 with one surety of like amount.
Highly obliged.
अभिषेक ये चैम्बर में ले लेना डिक्टेशन याद कर.
Lordship, item 59 mandatory period is over here, Lordship. 100 days. 59. CD is available here.
59, yes, Mr. Sharma. CD is available. It is a NDPS case.
No. Yes.
For how long you are behind the bars?
101 days, Lordship.
But only thing was one of the folks was done for bail by.
Whether that order is there.
Next year, Lordship.
Okay, I'll go through the record and pass orders in chambers.
Privilege, Lordship, the item 57, Lordship.
Potul, 59 chamber Uddibu.
This one.
Lordship,
Yes, case Darish. Yes.
item Lordship 57, Lordship.
Lordship, because I received your lordship. Today I have completed 41 days in custody and there have 4 of the sections, your lordship.
No hearing now.
The Lordship
No hearing.
57.
Only 7 years of imprisonment.
Saturday.
Two sections are
So
bailable and two sections are non-bailable. They are those are the 7 years of release.
49 is series matter.
14 is Saturday, my lord, maybe Saturday.
Ms. Mehdi, what is your item number
41 days completed.
on Saturday?
So item 57.
Today is 59 days.
Saturday.
Lordship 57, Lordship, today is 59 days, Lord. Item 57, Lord. Today is 59 days in the immediate, no recovery from my position, Lord. 57, Lordship, supplementary. Lord.
Fifty-seven or record to the Bobito.
May I please, your lordship? I beg to mention item number 58, lordship. This is POXO matter, lordship. 205 days I am behind the bar, lordship. Already charge sheet has been filed beyond the period, statutory period.
No, I am not taking.
Next week, lordship, on 20.
I am not giving dates, because registry will be giving dates on
Date
all.
is not given, this is very difficult to list, lordship.
No.
This is our difficulty.
And if dates are given, this is the situation which happens. If dates are given by the court without knowing how much matters are there on board. So let the registry
If
fix.
date is not face that it is very.
You
difficult.
may mention if it is not listed in the next week.
Lordship, it is on 23rd, lordship, Tuesday.
If I start giving date in one case, I have to give dates in all the cases.
Saturday is open, my lord. So I pray, my lord. Saturday given, my lord.
Which item?
Item number 40, my lord. 40, my lord.
Saturday is one request থাকলে দিয়ে দিব Saturday.
40, my lord. Item number 40.
Make request to
My lord. 40.
Saturday, may
40.
Yes. Item number 9.
Yes, yes,
58.
no.
Others I have mentioned, and if you insist, I will give date after 2 months.
Can be on Saturday, lordship.
I have already stated that make request to the court master. He will look in the board
Yes.
and accommodate. Saturday জিবলাকে বিচারে দিয়ে দিব.
Lordship,
Yes.
in this matter, the appearance of the CCC was very much important
Yes.
because of the fact that there was a allegation.
Today he was on legs.
Yeah, so now we want a date, like at least it is in the next week, like fixed, at least fixed.
Oh, 9.
I'm lordship fixed any other day, otherwise the
Suggested date.
WBC criminal is not maintainable, lordship. It's a force court, lordship. It's a court martial proceeding. You have to file the writ petition, lordship. Not the WBC criminal, lordship.
Okay, we'll consider. I don't know the facts.
It's a court martial proceeding, lordship.
You suggested it.
Actually, the base.
You suggested it. Don't go into the facts.
Oh,
So much time will not
no,
be
22nd of July.
22nd July.
Item 35, so interim there is.
Of like-
Interim maybe.
Wherever interim is there, it will continue.